scheduled caste. The Constitution, Dr. Ambedkar is the chief architect of the Constitution of India. Every court, including the Supreme Court of India, should have the photograph of Dr. Ambedkar, not Mahatma Gandhi. Mahatma Gandhi has nothing to do with justice. Mahatma Gandhi has nothing to do with the administration of justice. Mahatma Gandhi has nothing to do with courts. Mahatma Gandhi has nothing to do with the appointment of judges. But his photograph is there. But the person who is responsible for the Constitution of India, preparing the constitutional scheme, its philosophy, his photograph is not there. Because he belongs to a particular community. That's only. It reflects the upper caste mentality of the school.
So that even the lawyers in the colleges are taught, the upcoming lawyers in the colleges, majority of the colleges teaches that Ambedkar, they don't teach Ambedkar's importance.
They have to teach.
No, do they in the...
yes, they will teach. They have to teach.
Okay, they cannot escape.
Because they cannot escape.
But how do they limit the teaching?
They cannot. If you want to teach Constitution of India, you have to teach Dr. Ambedkar. You have to take the name of Dr. Ambedkar. What is the meaning given by equality?
Okay.
What is the meaning given to equal opportunity? See, at each and every step, in the separation of powers of the state, powers of the center, everywhere, what is the intention? What is this intention? A particular provision, if they want to interpret. What is the meaning given by Dr. Ambedkar? Such in the Constitutional Assembly debate. So they have day in and day out, they have to take the name of Dr. Ambedkar. They will take, but they are not prepared to reflect the same.
Okay.
When they take up the profession, when they become judges, they don't take the Ambedkar. But when they want to interpret the Constitution, they have to necessarily take the name of Dr. Ambedkar. That's whereby in all these judgments, where the constitutional provisions are interpreted for the first time, Dr. Ambedkar's name will be there. Even the first amendment to the Constitution, Dr. Ambedkar's name they have taken. Even in the first case of reservation, the famous case of Balaji versus State of Parsis, the name of Dr. Ambedkar is taken. Declaration of emergency, name of Dr. Ambedkar is taken. Eliciting the powers of the President, name of Dr. Ambedkar will be taken. So everywhere.
So the other thing is, yes, we, in your point of view, we understand there is a caste rigid system in the judiciary, but our law also says there is advocates. You can argue the court case and you can win. But why there are no Supreme Court? You can find various advocates like Ramjit Malani, Abhishek Singh, all a political background, but they are becoming very famous. Why aren't there Dalit advocates becoming famous? Because advocates, anybody can go and argue a case. How is that functions then?
See, an advocate becoming a top player, it highly depends upon patronage of the judges. If the judges give you lift, you will become the very next morning a celebrated lawyer. So these judges will encourage their own caste. These judges will encourage those persons who are having similar social background. That's why they are becoming. See, Nani Palkiwala was considered to be the topmost lawyer in India at the time of the Constitution of India. Still, this Nariman is considered to be, Ramjit Malani considered to be, and there are another few lawyers belong to Parsi community. In the beginning, this Parsi community was patronized by the judges. So, whichever community is patronized by the judges, they will come up. So, all these people who are now on the top are only encouraged by the judges. Without the encouragement of, suppose I argue very vehemently, very lucidly, very powerfully, competently, but the judge dismisses my case, what would be my fate? What the client thinks? Or if I entrust this case to Mr. Tharakam, the judges won't allow him. So why should I lose my case? Tharakam may be a competent person, but I want result. If the judges are not in a position to give a positive result for these communities, they don't encourage. So therefore, you don't find any brilliant lawyer in the High Court or Supreme Court.
The so-called brilliant lawyer.
Yes, because there is no patronage. There is an encouragement.
Okay. In the sense encouragement, you mean there will be in favor of, so that you mean the judiciary also does not look in the say of neutral. It takes a stand, and it is always depending upon the caste like that. Okay, is that the reason, for example, K.G.Balakrishan, A. Raja, let me also want to comment your comment. A. Raja has been on the scam of 2G, but in the beginning there were big Tata, Ambani's, Neera Radiate, Barka Dutt and headlines today. Many people were there part of it, but now only Raja is there. How do you see this issue? Because is there something, or Raja deserves it, that we are following?
I don't think that Raja alone deserves it. Raja may be responsible for this policy of allowing this license in the 2G spectrum. But every decision, particularly policy decision, not executive decision, every policy decision is the decision of the cabinet, not a single minister. That is the constitutional scheme. Ours is a parliamentary democracy run by an executive. Executive is in the shape of a cabinet headed by a prime minister. This is the constitutional scheme. So according to constitutional scheme, every decision will be taken by the cabinet. Prime Minister is first among equals, not above. So every decision will be taken by the cabinet, executed by the individual minister related to this particular department. Suppose this decision related to economic policy, finance minister will be in charge of the execution. Suppose the policy relates to education, education minister will be in charge of the execution. Policy related to labor, labor minister. So likewise, this policy decision is taken by the union cabinet, given to execute to Raja, because he happened to be the minister of the commerce minister at the time. So if at all the minister is to be blamed, it's not the minister alone, the cabinet has to be blamed. Particularly, this policy is not only related to commerce minister alone, finance minister is also involved, because commerce and other things come under the finance department. So the finance minister is also responsible for it. That's why now there is an attempt by Mr. Subramaniam to rope in Chidambaram also. So finance minister is responsible, prime minister also responsible. You must know, you must have heard in the press that in deciding this particular, in finalizing this policy, Prime Minister of India is misled by his secretaries.
Yeah.
How could a Prime Minister be misled? Could you imagine? Is not a school boy to be misled? Prime Minister is misled by the secretaries. Own the responsibility. Responsibility is not yours, not responsibility is yours, not your secretary. So own the responsibility, take the responsibility. That's why Prime Minister is responsible for the 2G scam, Finance Minister is responsible for the 2G scam, entire cabinet is responsible for the 2G scam. But this, again the question caste comes. The power of caste comes here. So they want to only pin down, they want to sacrifice, they want to hang when the Raja, since he belongs to scheduled caste. If Raja belongs to a different caste, things would happen different. Probably we do not know where the 2G scam would be. They are trying, judicially now they are trying. Supreme Court, when it has decided the entire thing, why the Supreme Court left the decision whether to involve Chidambaram or not to the CBI court? Could you not decide? When the Supreme Court is taking the responsibility of daily investigation of this case, That is the duty of the investigating agency. Supreme Court is not the investigating agency. That is not his power. That's not the domain. It's not his duty. His duty is to judge the things at the final stage. Now Supreme Court has taken the role of an investigator. When the investigation is has taken this stage as investigator, he should investigate what is the role played by Chidambaram, why it left to the other courts. So the Supreme Court also wants to help Chidambaram. It wants to help the Prime Minister. They want to only call him Raja. So Raja is not alone the culprit. If at all there is a culpable role of a minister in the entire scheme, but these people also should be equated with Raja, but they are not doing it.
Our next question is about this SC/ST Atrocity Prevention of Atrocity Act. I find out across Tamil Nadu there is a opposition from even OBC communities that you should remove this SC/ST. That is one of the agendas they keep. How do you see this? And even many lawyers say that do not file the cases under SC/ST. You don't get justice. It is better you file without SC/ST for SC/ST people, they say. How do you see this?
Yes, but initially these upper caste, the caste Hindus or the non-scheduled caste, non-scheduled tribes, they do not want this act to become a law. They do not want this statute at all. It is a statute exclusively brought in to safeguard the interests of this community. Since they do not want it, so they are trying to rake up an issue to see that this act is abolished. This act is taken aback. So that's why there is an attempt to see that this act is being misused by scheduled caste and scheduled tribes. That is the propaganda they are making now. That is the bogey they are opening it. That this act is being misused. I say scheduled caste and scheduled tribes are not yet reached the stage of using any act. Forget about misuse. They do not know how to use a particular statute. They do not know about the statute itself. Even if they know about the statute, they do not know how to use it. Even they know how to use it, they don't have the wherewithal. They don't have the capacity. They don't have the economic standard to use a particular statute against their adversaries. So there is a question of misusing it. This provision, this act, is really a powerful act to protect the interests of the scheduled caste and scheduled tribes. It is an instrument to render some justice to the victims of atrocities by the hands of the scheduled caste. One important provision why these people do not want this statute to be implemented is there is a provision in this statute of denying anticipatory bail. Criminal Procedure Code gives an opportunity to obtain anticipatory bail when there is an allegation against a particular individual. So that provision is taken away by the statute. If there is no such provision, immediately if a case is registered against a particular person under the statute, he has to be arrested, put in jail. It's a non-bailable offence, cognizable offence. Cognizable offence means without warrant he can be arrested. He is arrested, unless the court gives him bail, he cannot get bail. So there is no chance of anticipatory bail, and there is no chance of getting immediate bail. So that's why they do not want this act to be implemented at all.
How about the judges? Do they also support this act?
Judges support this
act.
Yes. I will give you one example of Andhra Pradesh. You know, I said that there is no anticipatory bail.
Yes, sir.
But for quite some time, the High Court of Andhra Pradesh was giving anticipatory bail to them. And one day, it's really happened. It's a strange experience. One day, I was sitting in the court, in the criminal court, waiting for my opportunity. But my turn. Earlier, some cases were being heard by the judge. One case suddenly, I could hear that the advocate is arguing about bail, anticipatory bail, in the SC/ST Prevention of Atrocities Act. I was really taken aback. How the advocate is arguing anticipatory bail when there is no such provision in the Act. Then just I was watching. And the judge has readily granted it. Then though it is not my duty, I could not contain it. So I stood up. I am sorry for the intervention. Of course, I have no business to intervene. But when this court is granting anticipatory bail, when there is no such provision under the statute, I am sorry I have taken objection. The judge was stunned. He asked me, where do you get that? I said, look into the provision. Take the book. Then they referred. I quoted the section. You come to that particular section, the anticipatory bail provision is not there. Then the judge, because he could not see, vent his anger against me, he went his anger against the public prosecutor. Why you did not bring this provision to my notice? So then, from that time onwards, there is no anticipatory bail in India. But they invented another provision.
They amended?
No.
Okay,
they invented another device.
Okay.
Another method. There is one section in the Criminal Procedure Code that is giving inherent powers to the court. Inherent powers means any power. Powers are given in these different sections. But inherent power means beyond that also you can have power to do anything. So, what these people are doing is filing applications under this inherent powers. You have got inherent power, great power. So trash this FIR. This FIR is wrong. This FIR is false. But whether it is false or true, it is not the purview of the High Court judge at that time. So as soon as the crime is registered, these people are coming to the High Court, filing applications under Section 482, asking for stay, release of the accused. So as soon as an application under this statute is filed, the judges, yes, admit and granted bail, including the all provisions. No, I'm sorry, I'm not able to get that word. Is stayed. All proceedings are stayed. All proceedings, further proceedings are stayed. Further proceedings are stayed, including the arrest of the accused. So what they could not get in this under this anticipatory bail provision, so now they are getting it through this inherent power. So the judges are also helping in diluting this.
So two questions. Maybe if you're tired, we can end. Two questions. One is about the atrocities committed, like Khairlanji, Chundur, Karamchedu, and the Hyderabad Central University investigation, and those all things. The other thing is that this constitution, whenever the vindicative is like Satyam Babu, only Dalits are vindicated, Muslims and Dalits religious in this various issue. So this is the constitution law falls only on Dalits because the Khairlanji issue judgment. How do you see these all things?
Every judgment reflects the social background of the judge. So it depends upon the judge. So let us take the example of Khairlanji. Khairlanji is a very horrible, brutal massacre. 4 persons were butchered, 2 women were gang raped, brothers were forced to commit rape on their mother and sister. Such a heinous act was done. When they refused to do that, they were butchered, they were killed, and the dead bodies were thrown only on the ground that These people are scheduled caste, they have education and they have land. They do not want education and land to be owned and enjoyed by the scheduled caste person. That is again the dictum of Manudharma Shastra. That's why I said two parallel constitutions are running this country, ruling this country. Manudharma Shastra says these Dalits, these untouchables shall have no education. They shall not own land. So these people in Khairlanji, you leave this land to us. And they said no, this thing happened. The judge fortunately has given life imprisonment, but he refused to give death penalty. Why? Criminal Procedure Code says if you want to give death penalty, you must establish that it is one of the rarest of the rare cases. That is the formula evolved by the Supreme Court. But the judge who tried this case could not find that it is the rarest case. Could he find any other case worse than this, brutal than this?